Alrighty, good evening, everyone. Welcome to week 2 of Principles of Commercial Law. This week, we've got our first substantive topic. We're talking about bailment, which is, in most cases, a reasonably straightforward topic, which is why we start on it. We try and ease into things a little bit, and that gives us a little bit of leeway to really think about the legal relationships in addition to the doctrinal concepts of bailment as well. So there is some method to starting with an easy topic. I sort of flagged last week that the structure of these tutorials, I'll begin with a few key points, not a complete summary of bailment, but just a few things that I'd like you to think about. And then we've got some problems and hypothetical questions that we'll go through. There's the main hypothetical tutorial questions at the end of the study guide that we will spend the most of our time focusing on. But if we get through those with time to spare, there are a few other little activities scattered throughout the study guides that we will sort of circle back to and revisit. But if we don't get to those, that's fine. And if you did want to sort of talk about some of those, you're more than welcome to email me if we don't get to them in the tutorials. But just a few points about bailment that I'd like you to think about or focus on. And in particular, sort of thinking about the filler method and thinking about facts being really, really key to thinking through hypothetical legal problems and real world legal problems. The thing that I'd like you to do when you think about a bailment is to start with the good or the item that is the focus of the potential bailment. Really use that as the focal starting point for your thought process and your way of analyzing what's going on. So really look at what is it and what's going on with it, what's happening. Is it moving about? Is it changing hands? Is it staying in the possession of the one person? All that sort of stuff. And it's really important to use the good as the starting point. First, because we need to identify that it is in fact a good in order to even have a bailment. But the identifiability of the good is also important when we think about, is there a potential for it to be returned if we think that that's going to be relevant as well. So if you're reading through a problem and you're sort of a little bit lost with where to start, if there's something that you think might be a good, that's a really great thing to latch onto and to start with, because it will then help frame the way that you understand the rest of the problem. So my suggestion to you, and that's the way that we'll sort of try and think about this week's hypothetical problems, is start with the good, identify that and go from there. The next thing to do is to think about, you expand your scope and look at the parties who are involved. So the potential bailor and bailee. And really what we're interested in here is thinking about how do they deal with the particular good? What are their interactions with the item and with each other? And so this is really important when we think about Greenwood and Council of Waverley, where this was the case where Greenwood hired out the lockers at the beach, and then his possessions were stolen from the lockers. In that case, there wasn't a bailment because the council never took control of the goods. And that really alerts us to the fact that when you think about good first, and then think about, okay, well, who are the parties and what is their relationship with the good? That's how you can start to identify those types of nuances. You say, okay, well, if we're looking at the party and the relationship with their good, the council never had possession, so we can't have a bailment. So thinking about the relationship to the good is important. Thinking about the relationship or the agreement between parties is also, of course, going to be critical. So, for example, the adjustment of stock, where in some cases it might be a bailment and in some cases it might not, and the surrounding circumstances of that agreement are going to be crucial. You need to be able to pull as much information about that agreement from the facts as you can. And if you think that there might not be enough information based on the facts that you've got at hand, you need to be quite targeted in being able to think about, okay, what are the specific facts that I would need to find out that would alert me to this being a bailment, or that would alert me to this not being a bailment. So the good first, relationship second, and then the third thing is to then start to think about the different types of bailments. So, thinking through, is this gratuitous or for reward? Is this one where the good is expected to be returned or not? All those sorts of things. And then based on that, what are the duties? What are the issues or problems that have arisen in relation to the good? All that sort of complexity you can deal with because you've set up this really good foundation thinking about what the good is and what the relationship between the parties is and what their relationship with the good is. Does that make sense? So it's not really adding anything to the content. I assume that that's kind of down pat, but it's a way of thinking about and processing this analysis. I'm seeing nods. That's good. Were there any questions about bailment before we get underway with the hypothetical questions? No, that's good. I think that most of you would have covered bailment in contracts and some other courses as well. So the idea is that it's a fairly familiar topic to you, and we're just starting to sort of think about it in a bit more complex and detailed way. Let's move on then to the tutorial problems. And the first one that we have is Leanne and her neighbor Sue. Leanne lent her neighbor Sue a lawnmower, and the problem was that the lawnmower did not have a guard on it. And she told Sue that when mowing the lawn, she should wear safety glasses to protect her eyes from stones being thrown out by the blades. Sue forgot about Leanne's warning, and during the course of her mowing her lawn, she was struck in the eye by a stone. She's been told that the eye cannot be saved. So I'm interested to firstly hear your initial thoughts and reactions to what's going on here. And then we'll start to think about, okay, how do we incorporate these ideas into a well-structured answer? So either via the microphone or in chat, what are your initial thoughts for this one?
Well, I printed out the answer that you put on Moodle.
Did I already put that up?
Yeah, so did I.
Okay.
Great answer.
So I can tell you everything if you like. It's just repeating what you already wrote.
Okay, this is going to be a really short tutorial. Okay.
I can give some other points without having reading it right now. I mean, I only printed out just recently, so I started the question beforehand. Yep. And I went straight to that the duty of the bailer with regards to the quality and fitness of the goods. So to make the bailee aware of any potential danger that the lawnmower may have. Mm-hmm. So that's where I kind of started, and I started going through pretty much the similar sort of stuff that you did, and then I found your answer.
Okay, good. Well, as long as you did the thinking first, then that's the main value.
You haven't posted problem 2's answer, so I think we'll be good with that one.
Oh, good. Okay. I should say, and of course my notes are different to what I posted up. So, because it's just rolled over from last year. Don't necessarily take the referencing as a good model. I'm just looking at what I've gotten written down, and there needs a bit more referencing. So there's that caveat. But in terms of, let's talk through the actual strict content, which has already been revealed. So let's start with the obvious. What is the good that we're talking about here?
The lawnmower.
Yep. And then thinking about the relationship between the parties, Leanne has ownership of the lawnmower. It's her lawnmower, and she's giving Sue possession for a time because Sue controls the mower through use. So, and you see this in the example answer. Nailing down some of the terminology that we use to think about bailment. So, you know, control through use, retaining ownership, having possession. Those are the really key, I suppose, buzzwords that alert me to the fact that you understand and know what's going on here and know what the law is. And thinking about, because in your assignment, you know, the word limit is deliberately very tight, to encourage you to sort of hone your legal writing skills, in which brevity is itself a skill. So you have to be really efficient with your use of words, and you know, it's a great way to kill your word count by stepping out in too much length, you know, every, you know, sort of not verbatim, but every step of like the checklist of a bailment and things like that. You can knock off multiple points, like is done in this example, by saying, you know, they return ownership of the mole, but Sue has possession. You've ticked all the boxes without having to say, oh, bailment is when one party has possession and the other retains. You know, you don't have to go into excruciating detail to still communicate to me that you know what's going on. And then from there, you know, you've got more words that you can use in your critical analysis and your application, which is, as you know, critical. So yeah, thinking about the relationship, Sue has possession, Leanne retains ownership, and you know, referring to Pivovarov, there's a clear analogy here in terms of the bailor having a duty to disclose any dangers of which they're aware, and you know, once that has been disclosed, they're not liable for any damages that arise. And so, you know, there's scope to draw some interesting and useful parallels to the case law in this instance. And then we go from there. It's a pretty straightforward question, really. Was there any comments that anyone else wanted to make in relation to it? With the answer having already been revealed? Let me ask you this then, to inject a little bit of fresh life into the question. Let's twist the facts a little bit and say, rather than being, so still learning the lawnmower, still has no guard, and Leanne says, look, the mower's got no guard, you should wear eye protection. But instead of being hit in the eye, Sue gets hit in the leg and, you know, deep wound, gets infected. They have to cut her leg off or something. Would your answer change in relation to Sue's position? If she hasn't been hit in the eye, she's been hit in the leg instead.
I don't think it would change because, you know, she's lost her eye, so her eye couldn't be saved. Similarly,
okay, sorry. So she doesn't get hit in the eye at all in this sort of revised scenario.
Yeah. So I'm just making the comparison with her losing her eye. So her losing her leg, we would go through the same process. And Leanne, you know, has also discharged her duty as the bailor of the dangerous good. And therefore she wouldn't be liable for that injury either.
Yep.
Isn't the minimum requirement that the bailor inform the bailee of the danger of the goods as a minimum requirement? So as long as, whatever her name is, Leanne, informs her that she's done that, and then the bailee accepts the possession of the goods, being aware of that danger, I would have thought that it wouldn't matter where the injury took place. Perfect.
Yeah, absolutely. So the sort of the challenge is that she's given Sue this warning. Look, it's got no guard. You should wear eye protection. And if she gets hit in the eye, she's clearly just not listened or has forgotten everything that Leanne said. And that's really analogous to Pavovarov, where the bailor said, do not let a child anywhere near this. And they let a child near. So there's a really clear parallel to like the Bailey just did the exact opposite of what they were warned. In this sort of twist, it's not quite as clear a parallel because, you know, she could have worn eye protection and it wouldn't have stopped her from getting injured, even if she sort of followed what Leanne had said. But you're both absolutely right. The kind of the what's important is the warning of the defect rather than any kind of solution that's proposed or any kind of safety precaution that's offered with it. The only thing that you need to do to discharge that duty is to make the bailee aware of the fault or the defect or whatever's wrong with that good that makes it dangerous. And in saying it's got no guard, Leanne has still fulfilled that obligation. So we would expect that the outcome would still be the same. Leanne wouldn't have any liability in this instance. So yeah, good. Trying to trip you up a little bit, but you did very well. The other thing that I should say about this this question, and it's pretty straightforward, but is worth saying nonetheless, is the brief kind of mentioned that Sue might have a claim in negligence, but that's kind of outside the scope of this answer. The important thing is that, as this is a commercial law subject, I'm obviously not going to be testing your knowledge of areas outside of commercial law. So I wouldn't be expecting you to go into any of the details in relation to negligence. It's worth mentioning just because in this instance, the comparison to Pavovarov, where there was a claim for negligence attached. But in terms of answering your assessment tasks, there's no expectation that you consider or delve into topics that are outside this unit. But obviously out in practice, that's a little bit different. And you do need to be kind of alert to and aware of other fields of law. Even if you're not an expert in it, it's worth flagging to your client, look, there might be a claim in negligence. I'm not a torts lawyer. You'll need to speak to someone else, but you should be aware that there's this going on as well. But for this unit, commercial law is the only thing that matters. We can forget about all the others. Let's move on to question 2, unless there are any final comments about question 1. Cool. So question 2, which has not been revealed. So on a shopping trip, Peter tried on a dress at Fashion Wise. She pinned her diamond brooch on the dress to see if it went with the dress. And then she forgot it to take it off when she changed it back into her own clothes. The brooch was found by a shop assistant when she was putting the dress back on the rack, and she handed it to the manager, who, in breach of shop rules, put it in the desk. When Peter realized that what she'd done, she came back to the shop, but it could not be found, advised Peter. So again, we'll start off thinking about just your initial thoughts and reactions, and then we'll work through what an answer might look like. So what were the kinds of things that leapt out to you initially as you read through this question?
For me, obviously, Peter retains ownership of the brooch. She has not sold it, leased it out, put it on trust or anything like that. Mm-hmm. Fashion Wise shop assistant this is how I went down, that she was in possession of the brooch as a finder. Mm-hmm. And as a finder, she is a bailee because she's taken possession or assumed responsibility of the goods.
Yep.
The minimum standard of care is that of a vigilant, careful person acting as if the property was their own. So therefore, the same duties and liabilities of a bailee apply in this scenario, regardless of the fact of her being a finder. I kind of then went down like, well, she passed the actual possession from herself to her store manager as part of being her responsibility to take care of the item. I then said, well, the bailee must prove that they took appropriate care of the goods, and their failure to do so must not contribute to the loss. And it can be argued that the shop assistant gave the brooch to the manager, acting under reasonable circumstances, transferring the possession of the brooch to the store manager for a specific purpose, that is safekeeping. Now, I don't know if this is where it goes, but that's then that third party potential whereby it could be a sub-bailment. And the store manager holds the same duty as a shop assistant to Peter as a bailee under that third party liability. So that's where I kind of went with that. So regardless of whether it's with the shop assistant or the store manager, there would still be a duty to Peter. Then I kind of went off into some other sort of areas. So I'm just trying to read my notes, sorry. Then there's also that scenario of the fact that the brooch is of value. So it carries a higher standard of duty or care. And that brings into the whole effect of, I've got here, what does it say? The shop assistant has a duty to take such care of the goods as is reasonable in the circumstances, and to re-deliver the goods to the bailer as she directs. Failure to do so could be an action negligence. If so, the store assistant is not liable for the loss of the brooch, and Peter would have no recourse to claim against the shop assistant if she could prove that the theft. So there again, we're going down the whole issue of the potential theft. This is a bit all over the place. Sorry, these are just
That's
my
all right.
notes.
I think I'm keeping up.
Because the theft comes back to that WGH nominees where he was taking the ring home to show his wife, and the theft of the ring from his trouser pocket was proven not to be a negligent act because he was not responsible for the loss of the ring. Because a bailee is not an insurer of the goods, they do not have to take every precaution to prevent the loss of goods. So I went sort of around that sort of area, but the issue I had was whether or not this whole in breach of shop rules, I don't know where that went. So I wasn't sure so I went down the track of like, if there is a bailee-bailor relationship. It originally started with the shop assistant as a finder. She then passed the brooch to the shop manager, as I would propose was for safekeeping or to ensure the safety of the actual valuable item. Because it is a valuable item, she needs to take extra care of the item, and we could assume that she knows it's a valuable item because it's a diamond brooch. Obviously a theft or missing has occurred, and then the whole item or the whole idea of that theft could be disproved under the WGH nominees area, providing that they can ensure that they protected the property and that there was no issue of an intruder coming into the property to take the property, et cetera, et cetera. But as I said, my whole confusion was whether or not this breach of shop rules was an issue.
Mm-hmm.
And I quoted Pitt and Son as well with regards to the negate of liability if it was for the theft of the brooch. But
mm-hmm. Yep.
And it's not, and it's obviously a gratuitous bailment because there was no employee-employer liability. So there was no employee-employer liability because it's not a reward bailment. So it has nothing to do with that side of thing. It's a gratuitous bailment.
Yep, absolutely. Okay.
I was a bit messed up. Sorry.
No, that's all good. That's all good. I've taken some notes and I'll refer back to some of the things that you've said. But before we do that, did anyone else want to add anything else that they had been thinking about, or echoing some of Tammy's points, or anything that was raised that made you think, oh, yeah, I wondered about that too, or anything like that?
The part around the finders certainly came to mind.
Yep.
And then I went down this path of, well, when you're a finder, you need to pass that item back to its rightful owner, or really make strong attempts to find the rightful owner of that particular good. But then we're crossing over into another area there. So, but I did note that there is no requirement for delivery where goods are found.
Yeah.
So, yeah.
Awesome.
So, yeah.
Sorry, did you want to add something else there as well?
That was pretty much some of my initial comments anyway, that I started making around it.
Yeah. So Jivan or Amy, did you want to weigh in at this point?
Sorry, I don't have much more to add to what Tammy and
No,
Matt
that's all
said.
good. That's all good. Cool. Alrighty. So let's all good points. And I think really what we can say is that the ingredients are all there. We just need to put them in the oven and bake ourselves an answer. So let's sort of start at the top and think about what's going to be in Peter's best interest in this situation. What's going to get Peter the best chance of some kind of recourse in this scenario?
Negligence. I mean, the item's gone, so all she can do now is sue for negligence for the loss of the brooch.
Yep. I should have been more specific. So really what we're thinking about is that we want there to be a bailment in this. We want to be able to demonstrate that a bailment has arisen, because that then brings up, recourse for Peter.
So she has to prove that there was a bailment relationship in place and prove that the brooch was lost in the bailey's possession. So she needs to prove that she wore the brooch into the store, somehow prove that the brooch was on an item in the store and that it was passed to the shop assistant and it was through their fault that the brooch was lost.
Mm-hmm. Yep. So it's, the evidentiary ease of doing that is I suppose one thing, and we can assume that the facts that we're given here are perhaps capable of corroboration in some way, maybe CCTV footage or something like that. But for the purposes of answering this question, we would certainly much rather there be a bailment than not, right? And so in terms of thinking through how do we develop and structure an answer, naturally there's going to be some ambiguity, and we'll talk through some additional facts that we think would be useful to know and that we'd like to find out, certainly. But where there is ambiguity, as representatives of Peter, we'd be looking to say, we'd argue it in this way, and it's likely that would be a strong argument, or we have to acknowledge that this would be a weak spot in the argument, that sort of thing. But framing our thought process in the perspective of, we would really like there to be a bailment in this situation, is a good place to start. And we've really sort of identified that already. So as you said, Tammy, Peter has retained legal ownership of this brooch throughout, and possession has ended up in the hands of some other people. So we have to determine, 1, whether a bailment arises, 2, what the duties of the baileys are, and 3, the consequences of those bailments. So I think in an answer to this question, it would be good to start off with some laying the groundwork in terms of thinking about, no requirement for delivery. This is a bailment by finding, as we've discussed, and it's gratuitous bailment for safekeeping, all things that we've covered, which is great. The transfer of possession of the brooch from the shop assistant to the manager, as we've highlighted, is a really tricky sort of crux point for this problem. And as Tammy has said, sort of the strongest argument for Peter is going to be to argue that a sub-bailment has arisen. And in doing so, you'd cite Morris and Martin to say that Peter's lack of knowledge of the manager taking possession of the brooch doesn't prevent that sub-bailment from arising. So we're sort of dealing then with the bailee and the sub-bailee, and what has each of them done? They both have duties to act reasonably in looking after the good. And we need to decide, okay, has each of these parties acted reasonably in looking after the good? So we can sort of pinpoint on the fact that the disappearance of the brooch arises after the manager has taken possession and put it in the drawer, I should say. And that's important for us to know because presumably we can say that the shop assistant has acted reasonably in handing this valuable good to a superior to look after. There's probably a strong argument on the shop assistant's part to say, I acted reasonably. I'm just, the assistant here. I found this thing. I gave it to my higher up because, that's the way these hierarchies work. They'll know what to do with it. It's out of my hands. And there's probably a strong chance that argument would succeed. The difficulty is whether the manager acted reasonably, as we've said, in putting it in the desk drawer, which is against the shop rules. Really, what that alerts us to then as a key fact that we need to know is, what do these shop rules say? And what's the status of these shop rules? Are they, is it just a general policy for lost property? Is it a really strict procedure for valuable items? We don't know on the facts. And so that's a piece of information that we would really want to know. And in an answer, as you sort of said, Tammy, you kind of spent a bit of time thinking about, okay, what does this in breach of shop rules mean? What's the significance of this? In an answer, you could very much say a lot is going to turn on what these shop rules are and what's their status, what are the consequences of breaching them. So that would be, in an answer, that would be more than okay to identify that as having a big impact on the final advice that you're going to give. What the expectation...
Jacob, just on that, does that go back to some of what you were saying earlier with the whole filler process? What facts are missing? What facts do we need? So in an answer, you would say along those lines of, if the facts show, in needing to be able to resolve what this particular breach of shop rules means, we would need more facts. Is that something that you would go down? Like that's what you would basically put in that answer? Yeah.
So in an answer to this, I would probably expect, and there's flexibility in where these things appear. In this particular instance, I would say that probably the best way to structure it is to kind of build to this as being the kind of tipping point through all the steps that we've gone through already, identifying the bailment, identifying whether what the shop assistant did was reasonable, all that sort of stuff. And then we get to, okay, here's the turning point. Depending on what the shop rules say, this manager has either acted reasonably or not. That's where you could quite, successfully identify this gap in the facts. Then what you would do is you would start to talk through, okay, what are we looking for in terms of what these shop rules are going to say? Are we, if the shop rules are a really clear set of guidelines for, if you receive a valuable piece of lost property, the procedure is you go upstairs, you review the CCTV footage, you find out whose it was, you contact them via their customer loyalty card, I don't know. But, if there's a really clear procedure that's in place, that's quite reasonable, then breaching those shop rules we would expect would be a failure to act reasonably. If the shop rules themselves are quite vague or pretty unhelpful, then it might not be so unreasonable to act in breach of them. So you would, in order to produce a really strong answer, you would do more than just say, oh, there's a gap in this fact, it's hard. You would say, what is it about this gap that is so important? And what are we looking for that would fill it? And what does that do to help answer our question?
So if scenario B, like that, it was very vague, could you then say that whole, like a bailee is not an insurer of goods? It's, they're not there to insure the property. They're there to do what is reasonably acceptable to protect the goods or look after the goods. Is that where you would go on that point B, if the shop rules were vague?
Yeah. So, I wouldn't be expecting you to go quite this far in an answer, but let's say, to illustrate the point, the shop rules are that there's a lost property bucket at the front of the store, and any item that a customer leaves behind, the rule is you put it in the lost property bucket out the front. When the customer realizes, they come back, they pick it out, they go, kind of thing. But the manager has gone, gee, this looks pretty valuable. I'm not just going to put this in a bucket out the front of the store for anyone to take. I'm going to breach those rules, put it in this drawer where people walking past can't see it. You would expect that would actually be quite reasonable compared to what the rules say. So, yeah, the breach of the shop rules, depending on what those rules are, potentially points us to, okay, it was pretty unreasonable to breach those rules, or actually in those circumstances, the manager has acted reasonably. They're not an insurer of these goods. They don't have this crazy high standard. She's done something that is quite reasonable. On that same note, another bit of information that we probably would want that would be kind of useful to know is some of the characteristics of the desk. Is this, for one, a desk where the drawers can be locked? And if so, was it locked? Is this a desk that is in the back office away from customers? Or is it, just a cashier counter that's in the middle of the store where it wouldn't be too hard for a customer to, reach around and pull something out of an open drawer or something like that? So we'd want to know more about the rules to determine whether the manager acted reasonably or not in breaching those rules. And we might want to know more about the desk as well to determine whether putting it in the desk was reasonable or not. If she put it in the desk drawer, locked it, clearly that's going to be, a different standard to if she just, left the drawer open in the middle of the store and popped it in and just kind of left it there. So being able to identify those two gaps, really it's kind of the one gap, but those two kind of facts that we'd want to know, and being able to explain through why that's important, what kind of indicators would lead us to one conclusion or another, is going to help you really come up with a strong answer to this question. Does that make sense? Because I'm happy to spend a bit of time on that, because that's a really useful skill. And in terms of thinking about the filler method and applying these kind of lessons to practice where you won't always have all the facts, it is really important to get in the headspace of thinking of, you can't just know everything and you can't just ask for everything. You've got to be thinking really strategically about, why do I want this information? How am I going to use it? How's it going to affect the outcome of this matter? So thinking in that really strategic space is going to be quite important.
I know that we're acting for Peter, but on that note of saying that, okay, if we go down the route that the shop rules were vague, but the desk was lockable, so therefore the brooch was safe, then that would then negate liability on the sub-bailey. Would that be where you would steer with that? I mean, I know that we're acting for Peter, but I'm just trying to think through the two sides of the argument. Definitely.
And this is where we sort of talked about last week about, what makes a good problem solver, and being able to understand your client's interest is part of it, but also, being able to give clear, effective, solid, reliable advice is more important. And it's no good saying, oh yeah, Peter, I reckon we can, you want this to be a bailment so you can sue them. So, we're just going to have to run down that route when, the facts might indicate that, this probably was all fine, all reasonable. Peter isn't going to succeed. Really, it's in her best interest to be told that up front, rather than, going down a litigation rabbit hole or something like that. So obviously, we recognize that as Peter's representatives, we're hoping for a certain outcome, but if the facts don't point to that outcome, then of course we have to acknowledge that that's just not the reality. And in sort of constructing an answer to this question, you would note, here's the gap, here's the kind of factors that would lead us down one route. And if the facts did tend to lead us towards that, then, the manager has not acted reasonably, they will be liable to you for the loss. But if the facts are this way, it leads us down a different path, and the manager probably wouldn't be liable for the loss. And it's fine where the facts are too vague to make a really firm conclusion. It's fine to include some tentativeness in your final answer. You say, look, at the end of the day, we'll be hoping for there to be a bailment, and to demonstrate that the manager didn't act reasonably and therefore is liable. But that conclusion only works on a particular set of facts, and at this stage we don't have all those facts. We need to find out a few more things before we confirm that course of action, or something along those lines. So you're still coming to a conclusion, but you're accepting that, one, it's might be a bit up in the air. It might depend on particular facts emerging in a certain direction. And two, where the facts don't add up to what your client is hoping for, absolutely the best thing to do is to tell them up front, it's not going to work the way that you hope it will. any further questions on that sort of note?
No, it was really clear, Jacob, how you explained it.
Good.
Much clearer than mine.
No, that's all good, because it's, and here's the thing, right? Like this is why in this unit we do things the way we do, is because it's a kind of just the nature of legal study is that we give you guys a whole set of facts to test your knowledge of the law. And we give you as much facts as you need to kind of run with that. But now getting towards the end of your studies, we're getting towards, things looking a bit more like they do in practice, where you don't always have all the facts. And you do need to be able to identify where the gaps are, be able to identify what more information you need and where that goes. And so it's an adjustment to think about, okay, maybe I haven't been given the whole story, and maybe I do need to incorporate that into my answer to be able to reach some kind of a conclusion. So it's something that will just come with practice. And that's why we do it in these tutorials. That's why we talk it through, because I have no doubt that it will come to you very quickly. And then, once your mind's thinking in that way, then the clarity of the answer comes with it quite quickly as well. I'm just looking back through the kind of things that you said to see if there's anything else that we should add. The potential theft is a good point, and we've kind of covered it in the sense that a bailee is not an insurer. They don't have to protect against absolutely everything. If we did want to be a bit conspiracy theorist-y, we could consider whether the manager themselves took it, and was there no intruder and the manager is the thief, and it mysteriously disappeared from the desk drawer because the manager took it.
Well, I went on a couple of other notes that I didn't mention earlier around that theft and around the desk, the fact that it wasn't locked and another staff member took it.
Right. Okay.
You know what I mean? Like, I was sort of also exploring those sort of thoughts in my head as well, thinking, well, the manager, if we want to say that the manager didn't do the right thing, then the theft could have been taken from another staff member. I was going all out there.
Yeah. It's, I will say your assignment, your assessment will have some factual gaps. It won't have as many as this one does. And, I say that because, there are quite a few rabbit holes that you can go down. And, we do that to illustrate that you don't always have the facts, and you do sometimes need to start constructing advice based on incomplete information and things like that. So, there is the whole, just where is this brooch? Who took it? Blah, 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 does the store have CCTV? Like, can we just watch that and find out what happened? There's all that sort of stuff. Your assessments won't have quite this many holes, but there will be some gaps in the facts that you need to think about and work through. There just won't quite be that many. And I mention that because, it is easy to come out of this week thinking, oh my God, this first assessment is going to be just an exercise in speculation. And it won't be. It will be, you'll get plenty of detail to do a critical analysis, and there'll be enough gaps to prompt you to do that critical analysis, but there won't be this many. Any other questions about?
On that note.
Yes. Yeah. Of course.
With regards to the assessment, will you be giving us an idea of the sort of template or sort of the way that you want the advice to be written?
Yeah. So I'm talking through a couple of colleagues just to make sure that in terms of legal drafting and legal letter writing and stuff, every law firm has their own way of doing things, and so you need, I guess, some to be able to tolerate some variation and be somewhat adaptable. But I would also like it to be somewhat consistent in terms of what you're being taught across units. So I'm just getting a little bit of feedback on that. But then, from there, I will go through either next week or the week after. I'll sort of kind of like how I posted up the example answer too early this week. I will post up an example answer after the tutorial that is more in that kind of letter format. And so you will see quite clearly, the kinds of elements and the boxes that you need to tick in that regard as well. So there will be more scaffolding around the letter of advice side of things. It's just not coming yet because I want to give you guys a little bit more consistency in what you're being told across units. But that will come. Any other questions about assessment or about crazy missing diamond brooches? Cool. In the final couple of minutes, then we might just talk through the sort of tutorial activity questions that are scattered throughout the study guide. So the first one, 1A, A puts his suit in for dry cleaning and accidentally leaves an envelope containing cash in the jacket pocket. When he returns home with the suit, he realizes that the cash is missing and also finds the zip in his trousers no longer works. What is the legal relationship between A and the dry cleaner? So, just identifying the relationship. And so we're not, we don't need as much detail as the proper hypothetical questions. But what are your thoughts on some of these if you've had a chance to look at them at all?
I would have thought it was a Bailey-Baylor relationship. He's left the clothing with the dry cleaners. So they've taken possession of the property. And I would have thought that would have included any property within the garment.
Yeah. And so what I think is good about this, this little question is that it really illustrates why it's important to sort of use the goods as a starting point, because really kind of what we've got going on here are potentially two separate bailments. We've got the bailment for the suit and then the bailment for the envelope with the money in it. And so the first one is quite cut and dry in the sense that there's obviously a bailment that's been created. A has given the suit to the dry cleaner without handing over ownership. And it's for reward, presumably the dry cleaner is getting paid for this. And two, it's for a particular purpose. So cleaning the suit. We need to find out whether the zip, whether the dry cleaner was responsible for the problem with the zip. The facts say no longer works, which implies that it did work beforehand. So I think it's probably a pretty reasonable assumption that the dry cleaner has stuffed up in some way and caused the zip to no longer work, in which case we would expect that they would be responsible for that particular problem. The envelope might be a little bit of a different matter in the sense that because, It was just in the jacket pocket. It was accidentally left there. It's probably more likely to be a bail, still a bailment, but probably more likely to be a bailment by finding. It not for reward, so gratuitous, and so there would be a different different standard of care that would be applied, and so potentially the loss of the envelope wouldn't be a problem, but the defect of the zip would be a problem. Does that make sense?
Unless a dry cleaner thought the envelope was his reward for cleaning the clothing.
Well, I think that would be cleared up pretty quickly when A then took out his wallet and said, "Oh, thanks for cleaning my suit. Here's that money." And they're like, "Oh, didn't you already pay me?" So, but good point. Creative thinking. I like it. We've got time for one more. Let's jump down to 2A. P delivers his yacht to D for repair, and it's placed on shore on a cradle. D advises P that he's not equipped to carry out the necessary work, but before the yacht is sent to another repairer, it's blown off the cradle in a big storm and damaged. What are the problems, or what are the legal issues?
I again have it here as a Bailey-Baylor relationship, and that the yachtman owes, the repairer owes, and it's a reward. I would assume it's a reward.
Is
element. Well, if he's taking it, if we look at the first part that he's delivering it for repair, a repair could be a paid service.
Yep.
So I broke it down. So I started there with that particular side of things, that it was a reward bailment, and then the duty obviously applying to that particular reward. But the legal issues then I went down was that the liability of passing the yacht on to the next repairer, there could be a couple of different issues, that if there's a contract in place, being a reward style bailment, that could have those exclusions in there. So the exclusion of liability, those types of things. So I was kind of like bringing up a couple of different types of legal issues there.
Yeah. All really good thinking. And I mean, again, we're sketchy on the facts here, but there's an argument that it's actually a gratuitous bailment and not a bailment for reward, because P has delivered the yacht to D. D's got it up on the cradle and gone, "No, this is beyond me. I can't do this. This needs to go to someone else." And in doing so, they're not fixing it, so they're not going to be paid for it. In which case, it's not for reward; it's a gratuitous bailment. Obviously, we need to know a little bit more about the arrangement. Is there some kind of payment just for the diagnosis of the problem? In which case, absolutely, yeah, it would be a reward, a bailment for reward. But if D's not being paid because D is sending it on to someone else to be repaired, then maybe it's a gratuitous bailment. There's still a bailment. There's still a requirement that D take reasonable care to look after the yacht, but that nuance between gratuitous and reward potentially, leaves us down a different path in terms of whether that reasonable standard has been executed or not. So
does that come under that whole technical skills and ability to do the work? So if it comes into the yacht yard and under that, the Bailey has a right to refuse the repair because they don't have the skill set to be able to do it. So therefore no money at this point in time, or no reward is taking place. So therefore that's how it can fall under that gratuitous.
Yeah, pretty much. Yeah. So it's a tricky thing, and we don't have all the facts, so we wouldn't know for sure. But the point of this one, kind of like the point of the other one, is to is to really concentrate on the good. The point of this hypothetical is to really think about the relationship and whether it is gratuitous or for reward or not. But that does take us past the 7 o'clock mark. Thanks so much for coming along. Thanks to those of you who are watching this later on for your attention. Just a very quick kind of recap. I think, you know, apart from the key focus on bailment, obviously, as being, you know, a set of content that you really need to know, I think that this tutorial has really shown you guys the importance of focusing on the facts, identifying the facts that you have and what you can do with those, and then, you know, the gaps in the facts and where you need to take those as well. We'll be back next week to talk about sale of goods, which is a little bit of a step up in terms of content compared with bailment, but a little bit of a step down in terms of the facts are usually a little bit clearer. You know, as long as we can meet some of those criteria under the Sale of Goods Acts, we're usually pretty straightforward with what we're doing. So looking forward to seeing you all then. In the meantime, please do feel free to post any questions that you have on Teams or Moodle or email me. And other than that, have a great week, everyone. I'll see you next Thursday. Bye.
Thanks.